Any mention?
May I please to mention a matter, Your Lordship. This is item number 25. I am mentioning upon notice. This is that 24. I am mentioning upon notice. This is that IBC matter where the challenge to the demands of the Meghalaya State Electricity Board.
Yes.
Yes. I was only humbly beseeching if this matter, because what I understand from my learned friend, if the business of the court permits, if it can be taken up today early, or it can be fixed on a particular day so that we can finish off this matter.
You sort among yourselves. Today will be a bit difficult because
Difficult, yes, Your Lordship. 4th, we have...
We had concurred 4th April, Your Lordship.
Yes, as per the council of the party, this is a matter on 4th April 24. Yes.
Interim order to continue till such time.
Tomorrow continues till next date. It's only until further orders, I think.
Yes, Your Lordship, until further orders.
Yes, okay. 4th April on certain on priority, Your Lordship. That's the only indulgence.
Doesn't matter, no priority for
No
obsession.
priority. It will be taken.
Grateful, yeah.
All cases are important. Yes.
May it please Your Lordship. Lordship, I beg to make a mention of item 19.
Number
19, Lordship.
19.
Lordship. I'm for the respondents here, Lordship.
Yes. Who's for the petitioner?
For the petitioner, Lordship.
Yes.
I'm for the petitioner.
Your objection?
No, Lordship. Maybe short time, maybe.
1 week, yes.
Obliged, Lordship.
Much less, Lordship.
My please, Your Lordship, I beg to mention item number 20. When you have this matter next week, Lordship?
Who's appearing for the respondent? What's the matter about?
Payment of graduate skill pay, Lordship.
Not next week, Your Lordship.
Graduate skill pay, Lordship.
After 10 days, Your Lordship.
Okay, 2 weeks, yes.
2 weeks. Apply, Your Lordship.
May please, Lordship. Lordship, I beg to mention item 14. I pray that this matter may be taken up after 2 weeks.
Senior has come back.
No, Your Lordship.
Yes. The absence of the argument senior counsel is matter of
2
1
weeks.
week.
2 weeks, Your Lordship.
Come back 2 weeks.
Yes.
2 weeks, yes.
I do.
Yes.
Lordship, I beg to mention item number 21.
21. Yes.
I just received the affidavit today filed by the
No, this
respondent.
is not a matter, only reserve judgment, no.
No, Your Lordship.
I am appearing on behalf of the respondent number 7, my lord.
Who's the one number 7?
My lord, City College, Kolkata, my lord.
My Lord, I'm appearing on behalf of respondent number 6.
When you received the rejoinder?
Today.
This morning, Your Lordship.
Who filed it?
We filed it, Your Lordship. Respondent number 6.
Then 2 weeks, yes, we'll receive a
Your Lordship, if 3 weeks time...
We have already filed our affidavit.
Very good. You get a fixed date.
Your Lordship, if 3 weeks time...
Yes.
If 3 weeks time can be given...
Why?
Because on some of the pages, the notary did not sign, Your Lordship, so the registry has marked it as a defective, so we have to send it back, Your
3
Lordship.
weeks, yes.
Obliged, Your Lordship.
I beg to mention item number 23, Lordship.
Number?
23. 2 weeks, Lordship.
Why? Where's the other side?
23.
No objection, Lordship.
Master.
Yes. 2 weeks.
Please, Your Lordship. I beg to mention item number 25, Your Lordship.
25?
Yes. I pray for 3 weeks' time, Your Lordship, because our record got burned in fire incident.
Council prays for 3 weeks' time to reconstruct the records. Yes.
Obliged, Your Lordship.
May I please, Your Lordship? I beg to mention item 15.
15. Yes, Ramthao.
No objection, Your Lordship.
One week, yes.
Your Lordship, similar prayer for item 22.
This is the whole list is gone. 1 week, yes.
Very obliged.
All of matters.
Supplementary list, item number 1.
Yes.
My lord, I beg to mention item number 17 and 18, my lord.
Why you didn't mention all along?
My lord.
17, 18.
17 and 18, my lord.
What is this? On whose behalf?
My lord, on behalf of Mr. V. Kumar, my lord. He has some personal difficulty, my lord.
Okay, 3 weeks is. Yes. Yes, Mr. Dev.
May I please, Your Lordship? My Lord, I am here before this Honourable Court to challenge the appointment of respondent number 6, my Lord, herein, my Lord. He has been appointed in the post of a professor in Nehu, my Lord. My Lord, if my Lord may kindly come to Annexure 3, my Lord, page 46, my Lord. This was the employment notice dated 16 March 2022, was published by the Registrar of the Nehu, my Lord, whereby, my Lord, a post was advertised, my Lord, which is in the next page, my Lord. 47, page number 47, serial number 9, my Lord.
Okay. Professor.
Yes, my Lord. It's Library and Information Science, my Lord. Now, my Lord, may kindly see page 51, my Lord. The other terms and condition of the advertisement, my Lord. If my Lord may kindly see serial number 2, my Lord, of page 51.
Yes.
The eligibility criteria of the candidate and other terms and conditions shall be as per the UGC Regulation 2018, latest regulation as the case may be, and their subsequent
What's
notification.
the ICTE?
Is All India
Technical
Council for Technical Education, my Lord.
Okay.
Now, my Lord, guidelines.
Why comes the AICTE? Library Science.
It is not under AICT. It is under UGC, my Lord.
Okay.
Further, the candidate are apprised that the UGC has issued notice dated 14 June 2019 regarding the UGC care list will be considered, my Lord. Now, my Lord, this was...
the UGC, the apprised UGC has issued notice. What is the UGC care list?
It is a list, my Lord, where the publication of the professor or the person who want to participate, my Lord, is published, my Lord. Their generals, my Lord, are published, my Lord.
It's called a UGC care list.
Yes, my Lord. And they have given certain certain criteria, my Lord. Page 54, it is there in page 54, my Lord, may kindly see.
Yes.
If page 54, Annexure 5, these are the generals if I publish my...
What is 54?
Page 54, my Lord.
What
These
is
are
this?
This is the list, UGC care list, my Lord.
Okay.
And there are 78 care lists, my Lord. Now, my Lord, may kindly see the page 51, my Lord. Serial number 2, my Lord.
Yes.
So they say that, my Lord, they will consider 2 UGC care lists, whoever has published in UGC care lists. Now, my Lord, may kindly see the regulation of 2018, my Lord.
Yes.
My Lord, may kindly see 3, my Lord, recruitment, page 58, my Lord. Page 58, serial number 3. Recruitment, yes, my Lord.
Okay.
It says, my Lord, 3.1, I will read 3.1 and 3.2. Direct recruitment to the post of assistant professor. We are not concerned with assistant professor or associate professor. We are concerned only with professor, my Lord.
Okay.
Shall be on the basis of a merit through All India advertisement, followed by selection by a duly constituted selection committee as per the provision made under this regulation, my Lord.
Yes.
Now, my Lord, if my Lord consider 3.2, the minimum qualification required for the post of professor shall be specified by the UGC in this regulation. In this regulation, my Lord.
Yes.
Now, my Lord, may kindly come to page 59 of the same regulation. How a direct recruitment is supposed to be made that is in clause 4, my Lord.
Yes.
Now, my Lord, 4.1 speaks about for the disciplines of arts, commerce, we are concerned with library science, my Lord.
Yes.
My Lord, may kindly come to the next page, that is on page 60, eligibility. The last para, eligibility.
Professor.
Yes, my Lord.
Yes.
Eligibility, my Lord. An eminent scholar having a PhD degree.
This is clause.
Yes, having a
Roman 3.
Yes, Roman 3, A1.
E1.
Yes. An eminent scholar having a PhD degree in the concerned discipline and published work of high quality activities engaged in the research with evidence of published work with a minimum of 10 research publications in so-and-so and UGC care list, my lord. There was 2, my lord, either, my lord. Now, my lord, this has been amended by a notification dated 14 June 2019, my lord. That is on page 53, my lord.
Of your petition?
Yes, my lord.
Now it says, okay, let's understand. It says, eminent scholar having PG degree in a concerned allied relevant discipline and published work of high quality, actively in search, so and so, with a minimum of 10 research publications.
Yes, my lord. In 2 different lists, my lord. Either UGC list, UGC care list, or, my lord, peer reviews.
Where do you get that from? It's not here.
Yeah, here only, my lord. Publications in the.
Okay.
Now, my lord, may kindly see page 53, my lord. Point number 2, my lord. That is notification dated 14 June 2019, my lord. Serial number 2. If my lord kindly come to serial number 2.
Yes.
Any publication.
Yes.
This, my lord. The last
Yes.
2 line, my lord. With immediate effect, research publication only for journals indexed in UGC care list should be used for all academic purpose.
Okay.
So it is only now UGC care lists remain, my lord.
Only those journals appear in that care list.
Yes, yes, my lord.
Only published there.
Yes.
Then you'll be in a zone of consideration.
Yes, yes, my lord. Now, my lord, may kindly come to page 56. That is notification dated 16 September 2019.
Yes.
Point 1, my lord. The old UGC approved list of journals has been replaced with a new UGC care reference list of quality journals, and with effect from 14 June 2019, research publication only for the journals indexed in UGC care list should be considered prospectively for any academic purpose, my lord. Now, my lord, this notification is of 2019 and the advertisement was of 2022, my lord. Now, my lord, may kindly come to page 59, my lord. This is the, my lord, Nehu ordinance, page 59, my lord, serial number F and G, my lord.
Okay.
If I'm permitted to read.
Yes, please.
The qualification advertised in the notice shall not be relaxed unless the fact that qualification are relaxed under specific circumstances.
Are relaxable.
Yes, my lord. So it cannot be changed, my lord, until unless they give something, my lord. Now, my lord, may kindly see page 76, my lord. Respondent number 6, my lord, he has only 7 publications in the care list.
He is Shukla.
Yes, my lord.
Akhandanan.
Yes, my lord. Please. This is the extract, my lord. We are just sharing the extract of his publication in the care list. So he has only 7 publications.
Latest care list, you mean?
Yes, my lord. On the day of consideration, my lord.
Okay.
Of his.
Should have 10 publications, you say?
Yes, minimum requirement, my lord. Now the second, my lord, first point was this, my lord, that he doesn't have 10 number of journals, my lord, published in UGC care list. The second point, my lord, is the composition of the selection committee, my lord. My lord, if my lord may kindly see.
Composition selection committee.
Selection committee, my lord.
Yes.
The ordinance of Nehu, my lord, that is in page 57. If my lord may kindly come to page 59, my lord.
Yes. We read F and G earlier on.
Yes, yes, my lord. 59, my lord, I have showed, my lord, to 59. Now, my lord, may kindly see the selection committee, which is supposed to be constituted as per the regulation, my lord, of the UGC, that I have shared, my lord, the resolution of 2018. Page 71, my lord.
Yes.
Page 71, my lord. The selection committee for the post of professor in the university shall consist of the following person. We are not concerned with 1, 2, 3, 4, 5. We are concerned with 6, my lord.
Yes.
The accommodation belonging to the ST, SC, OBC
absolutely compulsory.
Yes, my lord.
Yes.
Now, my lord, because the candidate, the petitioner were here in my lord, he has participated and he was an ST, my lord. So now, my lord,
post is reserved for ST.
It was not reserved for ST, my lord.
Unreserved post.
It was unreserved post, my lord. Okay. But, my lord, an ST has to be a part of the committee, my lord.
No, it says it cannot be ST, SC, can be ST, OBC, minority,
If
women,
any candidate,
disabled categories.
If any of the candidates representing these categories is the applicant.
Okay.
My lord. Now, my lord, may kindly see.
So you mean to say if the ST candidate, ST must be there in the post?
Yes, yes. In the
Okay.
page 63, if my lord may consider page 63.
Of this
writ petition.
Really jumping here and there, yes. Yes.
Now this is we got from the website of the NEHU, my lord. Where Dr. BBK Rumbai, my lord.
Yeah.
Actually, her name was what? Some Ghosh, my lord. She got married to a tribal and she has adopted the surname of a tribal. Now, can she be a part of the selection committee, my lord? If she herself, she is not a ST, my lord. Now, my lord, we kindly see whether the person is ST, SC, OBC. They said no.
But Dr. ISM is there, ST.
She was not an expert for ST, my lord. Because she was appointed Brinda Ghosh, my lord.
How do you say that?
My lord, I have made a statement, my lord, in my writ petition. And what I am saying is this, my lord. Dr. BBK Rumbai, my lord. She is Brinda Ghosh, Dr. Brinda Ghosh. But probably by Tangjat, my lord, she has changed her title. But by changing the title, my lord, can she become an ST? That has been clarified here on itself, my lord. Whether the person in the ST, SC, OBC category, they said no, my lord. And then whether she was appointed in ST, SC, or OBC category, they say no, my lord. It is unreserved seat when she has applied for herself, my lord.
Okay.
So that is my case, my lord. And I'm challenging this appointment, my lord, based on the.
What you said, the only thing is that he had only seven articles printed in those
yes.
UGC care thing. That's the only.
That is one of the primary issue, my lord. The second is this, my lord, the composition of the selection committee.
Okay.
That
you see, that is faulty.
Yes, that is faulty, my lord. Now, my lord, we have filed a number of RTIs.
For what?
For getting the appointment letters and other information, my lord. Mark sheets and all, my lord. They have never communicated, my lord. My lord may kindly see. Page 96, my lord. Even the
So it's absolutely mandatory that you have to have 10 publications?
Yes, my lord. That is mandatory, my lord.
So even the person is eminently suitable, more than the petitioner, also they can't be considered?
Sorry, my lord, I could not follow.
Suppose a person is more suitable than the petitioner, he can't be considered just because of...
Yes, because that is one of the criteria, my lord. That is one of the criteria.
No, I mean, is it watertight and criteria that you cannot, that's not relaxable?
But, my lord, the advertisement speaks that, my lord. Can it be relaxed, my lord? My lord, may kindly see in page 96, my lord.
Of the writ petition?
Of the writ petition, my lord. If my lord see serial number C, D, E, F, and H, my lord.
Yes.
All they have not answered to any of our queries by saying that it is exempted under section 8.1 of the RTI, my lord.
Yes.
So we are challenging this appointment, my lord, on the basis of
on two grounds. Firstly, that the person is not qualified.
Yes, my lord.
As per the advertisement.
Yes.
And secondly, that the selection, the constitutional committee also was not as per UGC regulations.
Yes, my lord.
Yes, Mr. Sen.
Yes, my lord. I am appearing for respondent number 1, 2, 3, and 4.
You take instruction notice or you want to argue?
I think I will need to file an affidavit.
Because the person is concerned is under challenge, so Param Fasai, Some case been made out. Will issue notice to the respondent number 6 that will appear.
Yeah, of course, I will not accept notice, my lord. That notice will go, your lordships.
Third,
I am accepting 1, 2, 3 and 4.
Third, Mr. SD, the counsel of the petition issue notice. Mr. SN, standing counsel for Nehu is present and accepts notice on behalf of
1, 2, 3 and 4.
1, 2, 3 and 4. Notice to issue to remaining respondents. So respondents 5 and 6. Yes, 1 second. I can see you. 5 and 6 within 3 days. MSP Agarwal is present.
Correspondent number 7.
For number 7. Stop. This is a matter for 3 weeks.
Well,
for instructions affidavit.
No obligation.
We'll keep this in the file for the time being.
Yes.
Regulations.
Item number 2.
Yes. Yes, Dr. Mosgawari, instructions.
My lord, this is the pension matter, my lord, where
Yes.
certain directions were issued. My lord, here what happened, my lord, at our end, my lord, as far as Assam Rifles is concerned, because there are two things required to be done. Because earlier the employee himself was getting the pension, my lord, so that has to be recalled. And a fresh pension payment, PPO, has to be issued, my lord. So we have processed the file and sent it to the pension authorities, my lord. But it appears that it will take some time at their end, my lord.
Why? Who's the person who's supposed to look after this?
is a
So
paid
when the
account.
matter was argued, the only requirement was that they supply some other documents.
That
which
has been
they've
done.
supplied.
That has been done, my lord.
And then why is it unduly delayed?
My lord, at Assam Rifles, we have processed everything, my lord. Now the Pay and Accounts Office of the Assam
If
Rifles.
an affidavit by tomorrow, we'll consider.
My lord, only thing is required, my lord, because at the respondents, the contemners here, my lord, they don't have any role now, my lord. My lord, if the Pay and Accounts Officer.
Who is the person who's holding the file? Implead him. We'll ask him to appear. Lieutenant General will not know anything. You should find who's the correct person who's.
It's the officer in charge of Pay and Accounts Office, my lord.
In the Assam Rifles itself.
My lord, it is a separate branch, my lord.
Doesn't matter.
Assam
We're not
Rifles doesn't
concerned about that.
exercise any
We're
control.
concerned about a person who's been, being
Since
deprived of
2018,
pension.
my lord. Since 2018, we have been before this honorable court. Second round of writ petition was filed.
File a short affidavit and you mention the time that will take and the court will consider. Yes.
If that they could implead that person, my lord, that officer.
Yes, you find affidavit, you state an affidavit, that's how he'll come to knowledge, not by oral submissions. Yes. Submits that the delay has been caused due to the time taken to process the pension papers, which is with another authority. Stop is directed to find affidavit within 2 days. Then matter come on 14th.
On Monday, my lord.
14th Monday, school not here. I don't know. This, like I said, this traveling court is big hassle for me.
Item
Yes.
number 3.
Yes.
Obligation.
Yes.
I'll check that.
Number 3, yes. Yes.
This is also a contempt, Lordship.
Yes.
But here's status quo was passed by lordship, my lord. This
Yes,
is
what happened? Why,
this is a
why,
transfer
why,
matter.
why you get a movement order after status orders are
My
there?
lord, the officer is here.
What is this?
The movement order, Your Lordship, and the contempt petition is at page 11, Your Lordship.
The matter is still under consideration. Why we should move an order? Why ask her to join, or her or him, whatever it is?
Him.
Yes.
But here, what they are saying, my lord, originally he was transferred to Mizoram, my lord.
Yes.
But, status quo was passed by your lordship, my lord.
Yes.
We have not sent him to Mizoram, my lord. We have attached him to another office in Shillong itself, my lord.
See, we can't run around circles like that. If the orders, of course, out of the court. Simple as that. Isn't black and white. If you don't comply with it, then you have to pay the price. That's all. We'll issue notes for contempt. Why contempt should be drawn up?
Lord, may I submit something, sir?
No, let your counsel submit. Yes.
That's the only justification. What they are saying, my lord, that he has not been sent to Aizol, my lord, but he has been.
Why he says that there's a direction that he joined? Where's that, Mr. Marpan?
Lordship, page 11 is the contempt petition.
Yes.
See, Lordship, here they have mentioned, Lordship, Santosh so was instructed to move forward, referring to a letter of 12 February, which was state. Now, whereas Honorable High Court had passed order on 16 so after handing over. Their explanation, this letter saying that
order came after the movement order. That is unacceptable. This is a contempt.
And now the petitioner, there was another letter issued after 2 days on 26. You can see on page 12 also. This letter again attaching me to a unit here in Damsanyong, the signal unit, which again there, if I am posted there, I won't. That is not my service. Because I'm in a record branch.
In this matter, we'll have to issue.
My lord, what they are saying, my lord, the attachment has been done to a different office because he was in the law branch only, my lord, and he was privy to the.
File affidavit, filed by the listed on Tuesday. Yes. The other DSG I praise for allowed to file affidavit. Yes. This is the matter on Tuesday, the 19th. 19, yes.
Daily list, item number 1.
You complied order, otherwise in this case there's something is there. Yes. Yes, Mr. Sharma.
This matter, Your Lordship, what happened is first the state respondent issued contract to one particular person, Sanjeev Das. His contract was cancelled on the ground that he has not completed the work within the time frame. Thereafter, state respondent has awarded the contract to me.
It's already been completed also.
No, it is not completed because the completion report submitted by the respondent
and if I remember, they said that is wrongly it was given to you.
Not wrongly. How can they take the money for the security deposit? The money they can be said that is by mistake. That mistake can be done in the, but they have taken the security amount also. Even in that they are alleging that the work has been completed. The report is not in the format. As per the Judge Jiban, there is a guideline that the 3 members should have the 3-person members have to give a completion report. Here is a affidavit filed by the state respondent. They have given only by one officer, which is not acceptable, not as per the format. It is issued by subdivisional officer because it should not be. But there is as per the guideline, it should have been submitted by the third party inspection. It is not by the third party inspection. It is done by only one single person.
From the department itself.
Lordship.
Third party inspection means what? Independent inspector?
Yes, there are 3 comprised of.
Who's the normal who normally does the inspection? Who's the third party in other projects?
The third party inspection is the. There will be a 2 person who will be signed. Yes, agency. The third party agency under Judge Jiban Mission government. They are the.
Who's the third party agency?
These are comprised of officers. As per the guideline, this third party will inspect, and the inquiry completion report will be submitted by. It will be signed by the minimum two officers. This is the third party inspection agency under Judge Jiban Government of Meghalaya. That has to be there. But here in that where they allege that completion certificate, this was submitted only by one particular officer, subdivisional officer, PSC, Bajeng Tuba.
Bajeng Tuba. Not Garo Hills?
Not Garo Hills.
So now your prayer is that to quash the impugn cancellation of work order?
Yes, and work should be
to proceed to give you the contract?
Yes.
Yes, Mr. Moomin, what do you want to say?
The third party, my lord, I'm furnishing it. I'm also furnishing it for this honorable court, my lord.
See, one thing, Mr. Sangma, the thing is that whether you like it or not, we can't help it.
Yes.
Time has passed. By now, you would have finished whatever it is.
The contract was finished.
See, this is by, who's the third party here?
Sir, inspection report, my lord. This is by the third party, my lord.
So who signs it?
Who's
this? Who's TPIA? Who's SQCE?
TPIA.
Of TPIA. What does it mean? Third
TPIA
party.
means third party inspection agency.
Inspection agency.
Inspection agency, my lord.
So what does SQCE mean?
You come here.
At least code also knows the abbreviation.
Abbreviation, I'm not aware, my lord. Just that this.
FE of TPIA means what? I don't know FE of TPIA.
Third party inspection agency, my lord. That
It
is.
looks like third party agency, but who's the signatory?
It's by the North Eastern Development Finance Corporation Limited, my lord.
No. This is who's
This
the
is the third
person
party.
who signed it? What is the designation? Who are they? Okay. Topan Bordoloy.
Thorpen Borderline, my lord. Yes.
He is the SQCE.
Yes.
What does SQCE mean also?
That I do not know, my lord.
Then is the site. The other one is. Where does it say it's complete?
This one on 12/10, my lord.
No, where does it say in this report?
Lordship?
Where does it say in the report?
No, it's E, my lord. Para E. The site of the above mentioned work was inspected. Para E, my lord. The site of the above mentioned work was inspected by the representative of on 12/10/2023 along with the
work
representative.
completed here. See at G, last column. So we'll close this petition. No, it will be futile unless you sue for damages.
Yes.
The red code, we can't do anything.
Yes, that's okay, but only.
We took security deposit from him.
Not yet, not
I'm not aware, my lord.
At
We
least
take security deposit from him for the work.
they have not returned the money.
If it is
How much
deposited,
security deposit you paid?
Some amount has been paid.
How much amount of work? Only 7 lakhs. What will be the amount? 7 lakhs 70,000 something. You pay 4 lakhs security deposit.
Lordship, we only say like that security amount may be refunded. That observation may be made because
if it is deposited, then that observation may be made, Your Lordship.
later on even the petitioner may have
Can a court
even come for that
pass
also.
order on hearsay? Where you have sent which paragraph said security deposit?
Yes, we have mentioned the petition.
Where is that?
So where I have mentioned it.
Because you see, Mr. Sangma, it's a matter that can't be taken by writ court. If you've done some work or you're entitled some money or you feel you've been wrongly cancelled, then
that is for the
yes. Where we said security deposit? Where we said?
I have mentioned somewhere.
Where we mentioned that after being settled, before the work order, before settling the work order with you, you paid security deposit. Where is that? Where is that? Where is that?
Nothing has been said, Your Lordship.
So the security deposit is the new case. Where? One,
no
even
such
a
statement, Your
whisper
Lordship.
also, then we will pass order saying at least for consideration. Mental harassment, infinite suffering, hardship, everything is there.
If Lordship kindly come to para 4 at page 5 of the writ petition.
Para 4?
Page 5, Your Lordship.
Yes.
He did not say anything, only he said that he have started the work as per the term and condition provided in the work order, and the petitioner have also invested huge amount of money for bank draft, challan, and for other expenditure. Nothing has been said about the deposit, Your Lordship. But surprisingly, the executive engineer RWS Division Resubal Para have issued another letter cancelling the work of the petitioner.
You withdraw the petition, you take liberty, you can file something else. Well, better instead of remarking in the order. In view of the production of inspection report dated 11/10/2023 by the respondent number.
No, this is third party inspection.
Yes, by it's one of the 4 in court today, showing that the work in question has since been completed. Mr. Peter Sangma prays that you will not withdraw the petition with liberty to seek alternate remedy. Yes. Matter stands closed.
Lordship.
You take a
Lordship. Most blessed Lordship.
Apply, Your Lordship.
Item number 2.
Your Lordship, here the respondent number 5 have to file their affidavits.
Yes. 5. MS Rumthao. When is the matter filed? 2022.
22, Your Lordship.
Were you just impleaded recently? Then? Then? August 2023. Then? This is inexcusable. What's the matter about?
Payment of outstanding dues, Your Lordship.
From whom? Who are you?
The ministry, Your Lordship.
It's compensation.
Yes, Your Lordship. The payment of outstanding bills, Your Lordship.
File an affidavit at least. Or you impleaded on July 23. Chief Engineer National Highways filed.
Lordship, yes. A state file, Your Lordship.
Dr. Mozika, only you find affidavit at least. Put the facts on whether you paid, you can't pay. Put the facts on at least. The case will move.
The contract is in 2008. We are not able to trace the record. That is what the main steps are.
A stale claim then.
Pardon me, Lordship.
Lordship, in fact,
Stale
Lordship,
claim.
the writ petition also involved disputed question of facts, Your Lordship.
If they, at least they need the affidavit necessary. If they can't fit, if it's a stale claim, then we'll court will pass the order. Yes, Dr. Mozika submitted due to unavoidable circumstances as the records could not be traced and the affidavit has not yet been filed. Please was allowed 3 weeks time to file an affidavit, short affidavit. Bring whatever facts necessary onto court.
Apply, Your Lordship.
Item number 3.
Please, Lordship. Lordship, I'm submitting the list of witnesses today.
It's not been given before.
No, Lordship. Only issues are framed on the last date.
Your list?
Lordship, I cannot file it as the respondent is out of station.
You cannot file it?
No, Your Lordship, we cannot obtain our instructions.
You file the next date.
Yes, Your Lordship.
Then we'll fix the schedule for examination. We'll get these cases going now. If our issues are framed, then we'll start recording evidence. Yes, Mr. B. Karim has filed the list of witnesses. Okay, the same is taken and kept on record. Up next by Mr. Impala. Sorry, not Impala. Next, on behalf of the respondent, an application for adjournment has been filed, seeking time to obtain instructions as the respondent stated to be not available. So, this is the matter. This matter of 2 weeks. List of witnesses on the part of the respondent will be filed, and on that day, schedule for examination will be fixed. So you come at convenient dates.
Okay.
They're convenient to both of you.
Go back.
But already we'll take it on the second half. So at least we'll finish it off.
Item number
How
4.
many witnesses do you have?
3.
3. Very good. You?
No idea, Your Lordship.
No witness. Very good.
I have, Your Lordship.
Item number 4.
Right, Your Lordship.
Yes?
Wait, please, Lordship. Lordship require weeks more time, Your Lordship, to file the paperwork, Your Lordship. We just received from the registry yesterday, so in the process of binding, Your Lordship. Your Lordship, I'm praying that Your Lordship may kindly direct the appellants to prepare the paperwork at the earliest since
She's
the
preparing it. She's hard at work. Yes, MS Bijurwa has got further 2 weeks' time to prepare the paperwork. Yes, this thereafter.
Much obliged.
Item number 5.
Yes, Mr. Mr.
My Lord, we filed a rejoinder on the last occasion.
Ready for hearing.
My Lord, my senior would be arguing the matter, my Lord. We were humbly
Why?
praying for 1 week's time. Personal difficulty, my Lord.
No, why can't you argue the matter?
My Lord, my senior wishes to argue the matter, my Lord.
Is the guy a should certificate?
Yes,
Your Lordship. Yeah, that is the case, yes, Your Lordship.
It's for orders today.
Yes, my Lord.
He's Party submit appeals complete as a matter for hearing is. Answer.
I oblige.
Item number 6.
My lord, we have filed the rejoinder, my lord. We pray matter may be listed for hearing.
Party submit that the party are complete is a matter for hearing. So. Yes.
7.
Excuse me.
My lord, I represent the respondent number 5, the managing committee, my lord.
Yeah.
My lord, I would like to pray for another 1 week's time.
Why?
What happened is, my lord, we have just discovered one more aspect which was not incorporated into my affidavit or positions. I need to change that. What happened was that...
You already filed affidavit now?
No, I have not yet filed. It's ready for signature. But last night we have discovered one more thing. Is that what happened is there, she is claiming...
What is your case?
It's a service matter, lordship.
As a teachers.
What do you bring the petition?
It's a non-payment of the salary, lordship.
Are you a sanctioned teacher?
Yes, lordship.
Yes. What's the
No,
problem?
that's not a fact, my lord. It's not. What happened was that initially this school was initially not under SSA, and then she stated that she was a sanctioned post. SSA came later on, and when SSA came, 3 posts were sanctioned. So what the managing did was, as per the seniority list, they were given for approval. It was approved. Her name superseded one of the other teacher who was senior to her. Now this particular teacher challenged before this court of superseding by the petitioner, and that matter went to the division bench also, my lord. Division bench has upheld her candidature was the contention. I'm sorry, the contention of the teacher was allowed.
The other teacher who said she's been superseded.
Yes, and her approval as an SSA teacher was revoked, my lord.
By the division bench?
Yes.
Let's see the order.
My lord, this is the order, my lord. 2703/2019, my lord. This was not brought, and I also just discovered yesterday, my lord.
Mujal Haq Mandal, he's party here.
No, he is not a party here, my lord. And this particular petition, writ appellant's name has been approved. And she has not disclosed that her name was revoked. Her approval order was revoked.
This is not Muzal Khatun.
I'm sorry, my lord.
See, here says, they said let's name the 3 teachers.
Yes.
Matri Mongal, SSA, UPS, Morokandi, also figure as number 90, which will be the name of appellant. Wrongly name was Muzal Khatun.
Yes. Now, pursuant to this order, my lord,
Were you party in the earlier proceedings?
No, lordship.
No, that's what.
A different person.
No, this I'll have to ascertain, my lord. That's why we just got it to knowledge. And pursuant to this order, my lord, pursuant to this division's order, the joint district mission coordinator has approved the name of this writ appellant, my lord. So now there's only 3 sanctioned posts. Because I was
to
trying.
be fair to the petitioner,
Yes.
and you have to include this affidavit.
My
You
lord.
include this order.
Yes, my lord. And even the
They found out whether she is a teacher at all involved in this early proceeding.
Yes, my lord. I need to clarify that part because this was too late for me. And even I wanted to see the writ petition also, because this is only the writ appeal, which I was not instructed in the earlier. They just happened to discover this, my lord. A week's time, my lord, I will.
Because this is a question of like mistaken identity. There's what a name Mojal, Haq Manzal, and Mojal
Yes.
Khatun, the first one the same person.
Yes.
Anyway, Mr. P. Ubin submits that due to the discovery of certain new materials, the affidavit cannot be filed. He plays was allowed for how much time?
My lord, 1 week's time, my lord.
2 weeks time to
2
file
weeks, my lord.
affidavit.
Deep knowledge.
What about our state respondents?
Lordship, we had filed our affidavit on the 8th to 2024, Lordship, and on the last day we had sought leave of this court to file an additional affidavit, Lordship.
Is it correct what Mr. Ubin is saying?
Lordship, I have to seek instructions, Lordship. This,
Then the affidavit should contain, because it should contain if there's suppression of any
Yes.
proceeding, that's a very serious matter.
Lordship. Lordship.
If
As
the
per my instructions,
petitioner
Lordship, I have to-
has suppressed that the matter will come to court once it's been decided.
Yes.
So that is. You are appearing for whom? MS Agarwal?
No, I'm in the next matter, my lord. The
Oh,
camera
very good.
takes some time to play.
The way you're appearing, I thought that you wanted to do make some submissions. Yes.
2 weeks, my lord. 2 weeks, my lord.
Lordship, we have filed affidavits, Lordship.
You want to file additional affidavit?
Lordship, we've already filed additional affidavit also, Lordship, but then that additional affidavit was made a mistake, Lordship. There was supposed to be a affidavit in opposition.
Yes.
That should have been a affidavit in opposition for respondent number 2, Lordship.
The other respondent is going to file separate affidavits.
Lordship, because we had filed earlier for respondent number 4. So for SEMAM, Lordship, for state mission for Abhiyan Lordship, SSA. Lordship, we had to file another affidavit. We received extra.
You're going to file another one.
Lordship, we had filed, Lordship.
Let's see it. Where's the affidavit? Then you got to change this one, because this affidavit says on behalf of state respondents.
Lordship.
There's a block mission coordinator. Then one affidavit signed by Mr. Pala. Then national affidavit again on behalf of. You take your call. Take down Mr. H. Khan submits that the area affidavits filed by the state respondents relate only to the replies on behalf of respondents number
2 and number 4, Lord.
Number 4. He prays and is allowed to file a separate affidavit on behalf of respondent number 3.
No, Lordship, 2.
Make up your mind. This is for whom?
Lordship, this is for 2 and 4, Lordship.
Then what other affidavit you want to file now for SSA?
No, Lordship, these are things, but then which was required as additional affidavit, Lordship.
But then we won't say anything.
Lordship.
If I rejoinder to it, you have already filed rejoinder.
File it, Lordship.
Let him file it for that. Yes.
Obliged.
Because you be careful, it should not be any suppression of any early proceedings. That's the only thing.
Item number 8.
May please, Lordship. Lordship,
Yes.
the affidavit in opposition has been filed by the respondent numbers 1, 2, and 3 just today.
Yes.
I need to produce the same and thereafter file rejoinder, my lord.
Yes, MSP was
Right.
is allowed 2 weeks time for rejoinder affidavit to the affidavit filed by the respondents. This accordingly, yes. On so.
9.
Please, Lordship. In this case, I may be given 2 weeks time to file my counter, Your Lordship.
Lordship, this is the pension, Lordship. They are not disputing. I am the regular cadre, regular employee, retired in the year of 2021. If I am not regular candidate, then if the service is not regular, then that is a different case.
Let me put my affidavit, Your Lordship. I'm not denying or it's neither.
So once you file it, then it's ready. You have instructions with you?
Not yet. That's what
the pension matter, we can dispose of in the
yes.
you have instructions?
This is the second time I'm asking time, Your Lordship. This
Who's
matter,
the person?
the matter was listed on the on the opening of the High Court, on the opening of the High Court. So I think I'll be receiving by next week.
You will? What are we saying?
I'm likely to receive by next week, Your Lordship. Otherwise, comment. I talk to the
next week,
officers.
because not necessary file the RPTP also.
Mr. Abraham undertakes a file affidavit within 3 weeks positively. Feeling which?
Feeling which is petition may be dismissed.
Don't make jokes. Yes.
10.
Yes, file within 3 weeks. Similarly, MBA Prasad allowed 3 weeks and file affidavit.
My lord, affidavits are yet to come, and
yes.
May please, Lordship. Lordship, please some time to find affidavit, Lordship.
1 and 2. What is 1 and 2?
Lordship, I'm also praying for some more time.
1 and 2 is who?
MPSC.
MPSC. Number 3.
Lordship,
4. 4 is what? Whom? 5.
my lord, here the issue concerned is little serious, my lord. What happened is that I am alleging somebody has submitted a false experience certificate in order to secure a job, my lord. Now, the private respond.
How do you substantiate that?
How do I substantiate that is, my lord, the advertisement requires 3 years of experience. The advertisement requires.
What post is this?
This is a state organizer Bharat Scouts and Guides, my lord.
Okay.
So now the private respondents have submitted an experience certificate stating that since 2016 she has been working as an assistant state organizer in a non-salaried on the basis of honorary.
In Bharat Scouts and Guides only.
Yes. Now the author of the experience certificate was the then secretary of the Bharat Scouts and Guides. Herself says that this is not a certificate that I've issued. I have issued the certificate since 2018. Now the thing is that if the certificate has been produced as 2018, then this particular candidate does not qualify because she doesn't have 3 years of experience.
That is your client?
Yes, respondent number 4. So, my lord, now all the official records will go to say that this particular lady, respondent number 4, have never worked since 2016. Only
in allegation, let's see.
My lord.
Yes.
Authority, the person concerned, has already filed a criminal petition which is pending before the dishonorable court. In fact, the matter was listed.
Criminal for quashing? Of what?
Because here I filed an FIR against the person who issued the certificates.
You filed an FIR? Why?
Here, the person concerned has denied that I have issued the such certificate.
What happened
so
is...
on that basis, we have filed an FIR. And now they have filed a criminal petition under 482 for quashing of the said FIR.
What happened, I'll just very quickly say, my lord.
So you mean to say that this person lied?
Exactly, my lord. They denied.
She was a competent authority to issue the certificate.
Exactly.
And you have 3 years experience.
My lord. But in fact now, he is denying that.
How will you go into that? Yes, sir.
My lord, she has submitted, respondent number 4 has submitted an experience certificate stating that she is working from 2000.
Where is that?
My lord, page 47, my lord. Page 47. May I read, my lord, please? This is to authenticate, my lord has the page. This is to authenticate the two following works of Mrs. Alvarina Nongsit, that she has conducted, led leadership, notably contingent of Philippines in the Asia Jamboree in 2009, and are as well as trained service in term and an exposure to committee and all these things. Although not fully empowered, Mrs. So-and-so has been serving honorary as a member of the State Executive and State Council of the Meghalaya Bar since 2016. So now
21 certificate. That means already.
Yes.
How many years?
2021. My lord, this one 2021 was issued
5 years
here.
experience, it means.
Yes, my lord. Now, my lord, the certificate which I say, or which the State Secretary says, is this one at page 44.
So, but if Mr. Sama says that's happened, anyway, yes.
So
After you file this case, after you file the case, you file FIR.
No, madam. Prior to that. FIR was filed.
So this is the one that, as how did this come to know, my lord? How did this come to? I'll just briefly state that, my lord. When this advertisement has come, myself, Dashimti Kharkungor, and many others have applied for this post, my lord, for the state organizer. Now, Dashimti Kharkungor was appointed through proper means as an assistant state organizer, and she has been
working in the same organization.
Yes, same organization. She is a permanent member. She has been through proper interview.
She knows that the persons are working.
Yes, she knows that. So what happened was that when this interview, or when the select list came up, this particular respondent number 4's name also appeared. So she was wondering that, because she knows she's from this office, how come 3 years experience she does not have? She applied for the job and she is in the select list now. So that is why she filed an RTI. When she filed an RTI before the Meghalaya Public Service Commission, she was allowed to go through the documents submitted by the respondent number 4. When she found out that the certificate, this experience certificate setting 2016, she knew that this lady never worked since 2016.
So never worked at all there?
Never worked at all there. So she has put a question to the State Secretary, saying that, madam, this particular lady does not work in our organization since 2016. How did you issue her experience certificate since 2016? Then she said, no, I've never issued her 2016. It's 2018 which I've issued her. That also, she never said that she will apply for the post. She wanted...
What's the date, you mean?
I'm sorry?
The date was forged later on.
It appears, my lord. It appears like that. So now, anyway, my lord, now what I am saying is, my lord, now somebody...
Now she's appointed with appointment letter.
No, my lord,
When was election held?
She was appointed by, my lord...
Have you made any prayer for interim stay
yes,
appointment?
yes, my lord. I had prayed. But today...
Where's the process? Now interview is over also.
Interview is over. She has given. She already got the appointment order also, my lord.
Where's the appointment order?
Her appointment order, my lord, is at page.
Okay, notification is here at annexure 15.
Yes, my lord. Yes. But today, what I would like to pray, my lord, just to assist my lord.
So they've been appointed where? This appointment order. Okay, 56. No, this is Dashimti.
Dashimti.
Where's the appointment order? Number 5. Have you been appointed, Mr. Sangma?
She has already joined, my lord.
Where's the appointment letter? You bring on the record. What instructions? If you go running around filing for quashing, you should have the basic instructions.
My lord, I would like to insist on prayer. I'm not asking for the stay anymore, because now I would like to insist, or today, since they are not coming up with affidavit, I would like to insist on prayer number 3, my lord. Because if the report comes before my lord, everything will be crystal clear, my lord. And I think there is no bar, my lord, in directing this.
No, let him file affidavit first.
My lord.
If it's not satisfactory, then court will pass order.
My lord. My lord.
Yes, Mr. Karwanlang, you won't file.
Lordship, I will be filing, Lordship.
You'll be filing. Your phone number?
For number 3, Lordship.
Number 3, MSB Karwanlang for. Number 3, MSB Karwanlang for 1 and 2. Who's appearing for number 4? 4 and 5. 5? Served.
Notice of served, my lord. It's
Who's
been-
number 5?
He's
The
also
other
another
person's
candidate.
reckless.
He is also another candidate, my lord. Here.
Yes, sir. Problem. If for allowed further 2 weeks' time, stop to file the affidavit. Stop. None appears for spot number 5. Stop. The matter appears to be urgent. It's expected that on the next day, the affidavit should be on board.
My lord.
This up to 2 weeks. Yes.
My lord.
File
Obliged.
affidavit.
Obliged.
11.
Yes, MS Colney.
My lord, as
After
per my
file.
my lord, I have not filed the affidavit. I'm apologizing for that. But the development here is, my lord, we have already forwarded all the pension books and the related documents for which the petitioner can receive to the accountant general on the 24th, my lord. This is the letter. And here, my lord, there is another letter in which we have certified that this person, the petitioner, is our staff, my lord, who has retired. So there is nothing from the department side, my lord, in which we are objecting to the petitioner receiving the pension.
Yes, sir.
So it will be the call of the accountant general now, my lord. I have not give a copy to my lord. Otherwise, my lord, I can serve the copy, lordship, if they have this on the board, my lord.
Contempt only when this
My lord,
willful
yes.
violation.
But this has happened after filing of the contempt only, my lord.
My lord, that I will not
That's
deny,
very
my
good.
lord. There has been some
So contempt
difficulty.
service purpose.
It's of the purpose, but however, because the matter is pending with the
Accountant general.
accountant, some
My lord, in
observation
this
direction may
letter-
be
In the observation contempt,
I
where's
also
that
have a receipt
MSC
note.
Pasar?
The receipt note is also here, my lord, which the accountant general has received. They
She was
can
here
be-
just now, that
They
lady.
can be directed, my lord. The second letter, my lord, we are certifying him as our employee, my lord. And the third letter, third paper is with regard to the receipt note of the entire letter.
So there has been a delay in complying with the
My
order
lord,
of
there
this
is a
court.
delay, my lord. That is,
Stop. From the documents produced by MS Alconi today, it appears that the pension papers of the petitioner and other related documents have since been submitted to the Accountant General A&E, who in receipt of the same. Stop. A certificate's also been given to the, has also been produced showing that the petitioner who retired from the, what office is this?
my lord, this will be the office of the Forest and Environment,
Who
my lord.
retired as a forest
Bakmara.
guard of the Balpakram
National Park.
Bakmara, has not been receipt of any pension or gratuity till date. Stop. As there's been no willful violation of the orders, the contempt stands closed. Stop. You-
Lordship, just one line because the just to direct the accountant general to.
They're not party here.
No, in the writ petition they are party.
Represent
My
disposed
lord,
of.
they can give a representation based on the document which I have shared with him, my lord. There's a receipt
give the
note also.
document to him also.
I've given him, my lord.
least the
He can
concerned
make a
department
Police
representation.
also shared the documents
Yes, I've already shared to him.
with Mr. Peter Sangma, who would take
Yes,
appropriate steps for expediting the payment of pension.
Lordship.
Well,
Okay.
Lordship. Also Lordship.
This, Your Lordship, this is connected to that contempt item number 3 in supplement. They have already filed the affidavit, so I would like to, I just received it just now, so I need to go through it and maybe a rejoinder may be required. It's quite a lengthy affidavit.
After we have respondent number,
All this one.
All the
I will file. Please for 2 weeks time before they joined up. This thereafter.
Pleasure. So the interim may be continued here.
My interim orders will continue like that. Why did that order that movement orders given on so and so, stay order came after that?
I told, that's why I called them. They're not.
Otherwise, they're going to Next day they're going to face the consequences.
They're not
Whoever was the
listening
author of that letter.
to any advice.
Yes.
Supplementary,
Let's
item number,
enjoy some civil imprisonment.
item number 4.
Yes.
Meet, please.
How long will you take?
Half an hour, minimum, whatever I curtail. My friend has argued for 2 days.
2 days. You are for 2 days, Mr. Sen.
Session.
You are more than 2 days.
2 days.
Spreading
Over 2 days.
Spreading over 2 days.
You won't make any replies.
Well, obviously, if necessary, otherwise no.
Otherwise we do be. You won't be curious. Okay.
Yes, my lord.
Where were we?
On the second writ petition, my lord, my friend was saying that first writ petition has become infructuous, but I will answer both the writ petition, my lord.
You want to see 299 first?
Second writ petition, your lordship, kindly see second writ petition first.
You want to see number 8?
Yes, 8 of 2, 2024.
Yes.
The prayer, my lord, kindly see the first prayer at page 6. It is therefore humbly prayed that may be pleased to consider the above, and after hearing the parties may be pleased to direct the state respondent to deploy the post necessary staff. Page 6 of the writ petition, my lord.
Page 6?
Sorry, 25, page 25. 25. There are so many pages. No. Sorry, 26. 25, 26.
Yes.
My lord, first declaration has been sought. Declare the withdrawal and posting of the staff by the state respondent from Amsarin Weighbridge of the writ petitioner of Amjeha Weighbridge as illegal and unconstitutional. Direct the state to respondent to post necessary staff to Amsarin Weighbridge of the petitioner. Declare the operation of Amjeha Weighbridge as illegal and unconstitutional. So prayer number 3, my lord, that administrative weighbridge set up by department should be declared illegal and unconstitutional.
The new weighbridge.
New weighbridge, because there is a prayer to declare it illegal and unconstitutional. And fourth, my lord, direct the state respondent to act in accordance with the renewal agreement dated 1st June 2022. So these are the two main prayers, my lord. Other prayers are consequential prayers, my lord. Now pleading, if your lordship will see the pleading briefly, pleading only 2 paragraphs are there. The rest of the paragraphs, the history of the case has been narrated, my lord. Page 21, paragraph 25, my lord.
Yes.
That writ petitioner states that the action of the state respondent in withdrawing its staff from Amsarin Weighbridge of the petitioner and shifting them to another weighbridge is clear violation and total deviation of renewal agreement of 1st June 2022. And this honorable court order dated for maintaining a status quo, my lord. And then your lordship will see next page 27.
27?
Page 23, paragraph 28.
Yes.
The writ petitioner begged to state that government entering into commercial transaction with private person is required to act fairly and reasonably. So it is a commercial transaction as per the petitioner, my lord, and the state is required to act fairly and reasonably, and state has not acted fairly and reasonably. According to petitioner, the state has not acted fairly and reasonably, and it is a commercial transaction. And the prayer is, my lord, that the withdrawal and even the refusal to renew the agreement is arbitrary and illegal, my lord. Before I go to the merits of the matter, 2 preliminary submission, my lord. What my friend has argued before your lordship is that the 14 July order has been withdrawn, my lord. And since this order has been withdrawn, if your lordship kindly see 14 July order, which is at page
Annexure 14, page 85.
85, my lord. Page 85. you are hereby informed that agreement for operation of weighbridge at Amsarain is extended up to 39 September 2023 as conveyed by government in their letter dated 20th June 2023. My lord, this 20th June 2023 letter, petitioner is having possession of. He has filed it before the division bench also. It is part of the rejoinder also, and this 20th June 2023 letter has not been challenged.
14.7.
What has been challenged in my humble submission is consequential order.
So 14.720 is a consequential order.
Consequential order, because every time, my lord, your lordship will notice, every time the petitioner has been communicated by Transport Commissioner of permission granted by state government, and pursuant to permission granted by state government, my lord, the period of lease has been extended time to time. In this regard, my lord, kindly see the previous letter at page 55, my lord, annexure 7. Every time the petitioner has been informed by the Office of Commissioner Transport of the permission granted with reference to the subject above, I am to inform you that the government has approved your petition to grant extension of operation of your weighbridge at Amsarain till the period ending 31st December 2020 under the same terms and conditions of the agreement signed with you. Further, you are requested to clear 50% of dues. So, the petitioner is aware that without permission of the government, the agreement or lease agreement or license cannot be extended by the Commissioner of Transport. And, my lord, two orders I have shown, 20th June 2022 order, my lord. I have shown, my lord, the previous order, and kindly see, there is one more order, my lord, of August 2023, my lord, that 14 July I have already shown, my lord, and then refusal is there, where the 90, page 90, thank you. Page 90, my lord, annexure 16. This is the letter of the Commissioner of Transport also, my lord.
So now you're making preliminary objections only.
First objection, only consequential orders have been challenged.
Okay, yes.
The second, my lord, what my friend has argued that there is an agreement of June the 2022, and that agreement is binding on the government. And since the Commissioner of Transport has entered into the agreement on behalf of the government by virtue of Article 299, therefore that agreement is binding, my lord. Your lordship is aware that Article 29 provides that the agreement on behalf of the government can be signed in the name of governor by the person who is authorized to sign it. If a person who is not authorized to sign it and enters into the agreement on behalf of the government, that agreement will not bind the government. Now the question which falls for your lordship's consideration is...
That is interesting. So you say even if the contract is signed
in the name of the governor, but the person is not...
the signatory is unauthorized.
Yes, if he is unauthorized...
While at the same time he's been doing the entire communication with the
he can only do the communication, because under the rules, who is authorized to grant permission, my lord? Your lordship has seen only government has power to grant permission. That fact has been acknowledged time to time by the petitioner, my lord. I will show the rules also. Under the rules also, only government has power to grant permission. All correspondences, everything will be entered by Transport Commissioner, but only after the government has granted permission, my lord. Kindly see the rules. I will show this part. Kindly see the rules in this regard, my lord. At page 29, rule starts, my lord. Rule 3 at page 30. Rule 3, my lord. The government may Rule 3, my lord, at page 30. The government may install and maintain by itself as many way bridges for the purpose of section 144 of the Act on such places as it may think necessary. I pause here, my lord. First part is the government may install as many way bridges as for the purpose of as. So therefore, the way bridge started at Amjeha by the government, my lord, cannot be sought to be declared unconstitutional. That power I have under the statutory rules, my lord. That is first part.
Okay, that's important.
Prayer number 3, where the declaration has been sought to declare that Amjeha Bridge illegal, unconstitutional. The government has power under the rules, my lord.
Yes.
Then second part, or may allow any private person, body or persons, company or organization to install and maintain such way bridges on payment of lease amount to be determined in each case by the government after calling tender. So, my lord, kindly note, the government may install and maintain, and government can grant permission as purpose of 140 on Act as it may think necessary, or may allow any private person or company maintain or payment amount of deal in each case by government. So it is the government which has to do it. And then proviso also that no lease shall be granted permission to any private person or body or person, company or organization unless after fulfilling all criteria laid down in 4, 5, 6 of these rules and permission from the government in transport department.
Okay.
So permission from the government, my lord, is sine qua non for grant of lease. Rule is absolutely clear, my lord. There is unequivocal.
Initially that was done. He was given due permission.
Government, I will show that also from both lease agreement, my lord. The 2017
subsequent event.
And subsequent event, there is no, even lease agreement is not saying that there is a permission. Kindly see if I straight away.
Yes, come to the section first.
Yes, my lord. No way without, my lord, private person, body or person compared shall not be eligible for obtaining lease permission way bridge under 21 and has made application for grant in writing to government in transport department through Commissioner of Transport. So the channel will be, my lord, Commissioner of Transport. Okay. And this is the Commissioner of Transport. My lord, kindly skip all those parts, my lord. Those are requirements. 5. Permission. In considering the grant of permission, Commissioner of Transport satisfy itself that the proposed place of installing an operation of way bridge should be fulfilling the criteria. These are the criteria, my lord. 6, my lord. Now, after satisfying himself that 6, Commissioner of Transport to forward the application to Secretary Transport Department. He is like post box, my lord, where the application will come to him. He will forward with this after satisfying the requirement, and it will go to the government under Rule 6, my lord. After satisfying himself that the applicant is complete and meets the requirement as laid down in 4 and 5, Commissioner of Transport shall forward the application with all required information to the Secretary of Transport for issue of permission. So it will go to the government for permission, my lord. The Transport Commissioner on his own cannot enter into.
He's not a competent authority.
He is not authority
to
under
any lease agreement.
He cannot. He can do it only when government has granted permission. He can do it only after government, because permission under the rule is of the government, my lord.
Okay. Yes.
Permission, Rule 3.
Rule says so. Yes.
Rules are unequivocally clear, my lord. And kindly see, in the light of this, my lord, 2017 agreement, my lord, at page 39. Page 39, Annexure 5, my lord. And on next page, my lord, my lord.
Yes.
The second clause, and whereas licensee had beside others submitted his application for the said purpose, and her application having fulfilled all the stipulated criteria was duly accepted by government, and licensee was given permission to set up. So accepted by government, 2017 agreement, my lord. And kindly see 22 agreement, 22 at page 64. Page 64.
Okay, now, where licensee besides others submitted, these things are very important.
Yes, my lord.
This is clause 2 in page 40.
Yes, my lord. It is all, the lease has been
Accepted by government.
Government, and it is without permission. Transport Commissioner has no authority to enter into the agreement, and your lordship has seen all the correspondences. The Transport Commissioner has forwarded those applications to the government, and there is no letter whatsoever from the government showing that permission has been granted. Letters are contrary, my lord. Letters are showing that permission is up to X date, Y date only. There is no permission of the government, my lord. And if your lordship will see the agreement, I don't, because your lordship knows that first agreement was in 2017, my lord. 3 years was over in 2020. Renewal, if he, in December 2020, renewal was over. The agreement was over. Agreement was over, my lord. Then renewal, even if in law or as per rules, the petitioner was entitled to renewal, he could have been renewed up to 23 only. His renewal cannot, even assuming there is a permission by the government, his renewal could not have gone beyond 23.
Where's the bar?
Because bar is that rule says, my lord, rule 3, that petitioner shall be entitled to renewal for a further period of 3 years. So maximum period which the licensee, if in the discretion of the government, is that 6 years. Not beyond 6 years, my lord.
The fresh permission.
Then I have to go through tender, public purpose will be served, I will get higher return, or I will run administrative weighbridge so that I will earn more revenue, my lord. The person may not have, and kindly see in the agreement, my lord, at 64.
Yes.
Your lordship will see there is no, in page 65, there is no such that government has approved, my lord. I will read both the paragraphs. As whereas the government had, by giving public notice on 14/4, invited the application from interested person for setting up the integrated check gate within the area of Amsrain, by utilizing the government for the weighbridge and motor vehicles for controlling overloading goods transport, whereas licensee had others submitted his application, having fulfilled the all steps, was duly selected and accepted by tender committee set up by government. Thereafter licensee was given to conduct so and so, my lord. Shall conduct integrated, where, and on next page also, there is no word saying that government has agreed for renewal, my lord. And in the first 2017 agreement, in clear and unequivocal term, it is that government has accepted. So the person who has entered, any officer, my lord, if I take it, tomorrow the officer who is not authorized and he enters into the agreement, and the other person also knows that he is not authorized under the rules, the government is not bound by any such agreement, merely because it has been expressed in the name of governor, unless it is authorized under Article 299 of the Constitution, my lord. That I have 2-3 judgments straight away on this issue only. So my first submission was, my lord.
So you mean to say that you've heard of sovereign action, correct?
Yes.
Sovereign action of an official.
Yes.
That means without a concurrence of the competent authority.
Yes, my lord.
This the Commissioner of Transport engage in sovereign action.
Yes, he cannot.
For which you'll have no liability.
No, I will have no liability, because your lordship, your lordship has seen Ralia Ram, the first where Ralia Ram, and when the question was of damages, etc. And the sovereign action plea was taken when the goods were stolen from the railway yard or railway godown or something. Then the government pleaded that it is a sovereign action and it is not liable to pay the damages, my lord. That was the first judgment in 1956. In that case, the
first judgment is one judgment during the East India Company.
Yes, before that it was
carriage,
yes,
that
carriage.
carriage
Your
is not
Lordship.
from, and then
Yes,
whether
Your
the
Lordship is
driver
right. You're right.
It was a carriage of the East India Company.
Yes, Your
and
Lordship.
whether that driver was in the charge of this or sovereign action on his own part.
That judgment is taught to us in Campus Law Center.
Yes.
The first year, law of torts.
Right.
Law of torts. That the judgment is taught. I remember. So what I was submitting, my lord, here that officer, my plea is this, my lord. We have to go by the rules of executive business, rules of the statutory rules. Officer who is not authorized to act on behalf of the government cannot bind the government, my lord. I give one example, my lord. Tomorrow, deputy commissioner, who is not authorized under the law, enters into the agreement with private person for installing a weighbridge in his district, where he is in charge of. Then that is wholly without jurisdiction. He has no power, and if he does it on his own peril. And similarly, petitioner who enters into the agreement, that petitioner cannot claim estoppel, equity, etc. because statutory rules are known by everybody. No equity against statutory rules, my lord. And the rules are also clear. If I can show, my lord, rules of executive business, my lord. Because if that plea is taken, my lord, there will be death knell of democratic system. All officers without approval of the minister in charge will pass the order, and then the government will be bound by.
I detected this thing after 1 year.
Now
happily letting him run the weighbridge then.
Now the question is delay on my part. Delay.
Okay, no, you just come
yes.
first. Yes.
I will
be binding. You have to satisfy the court first, and that first point which you're advancing.
Yes, my lord.
That this whatever agreement entered into has no is not worth the papers written on.
Yes, my lord. That is what my submission is, my lord. Rules of executive business is there. My lord, kindly see how these rules of executive business are binding, mandatory, and it is issued under Article Clause 2 and 3 of Article 166, my lord. And the department, how department has to function, my lord, if your lordship will see the page, under the rules of executive business, my lord, 22, Rule 22, my lord.
Okay.
Departmental disposal of business.
Yes.
Departmental disposal of the business, my lord. Except as otherwise provided by any other rule, cases shall be ordinarily be disposed of by or under the authority of minister in charge of the department, who may, by means of standing order, give such direction as thinks fit for disposal of cases in department. So all the decisions or cases have to be decided under the signature of minister in charge, my lord. If it is accepted, my lord, that the officers without having authority under the rules of executive business or without the approval of minister, my lord, merely because they have expressed the agreement in the name of governor, that will not bind the government, my lord, because law is very clear. Even Article 299 is also clear, my lord. My lord, on this point I straight away show the judgment, so that this point I will conclude. And
this is entire compilation?
Yes, entire compilation.
All the judgments.
All judgments. All judgments. First judgment, my lord, is Joshi Technology, and the paragraph 53 of the judge is relevant, my lord, at page 15(7) SCC, paragraph 53 onwards, my lord.
53?
Yes, my lord.
It is at page.
Paragraph
Page-
53,
internal page
29, my lord.
Yes. Yes.
We have to keep in mind
Yes.
that contract in question is governed by the provisions of Article 299 of the Constitution.
Yes.
Constitution. These are formal contracts made in exercise of executive power of the Union or state, as the case may be, and are made on behalf of President or by the Governor, as the case may be. Further, these contracts are to be made by such person and such manner as the President or Governor may direct or authorize.
Yes.
So, Your Lordship, such person and in such manner as the President or Governor may direct and authorize. So, here, if the contract has to be entered into, it has to be entered into. Thus, when a particular contract is entered into, novation has been made on fulfillment of all procedures. No doubt there is an exception to the principle, even in absence of contract, according to requirement of 299. Doctrine can still be invoked against the government. However, no such case is pleaded, my lord. To dilate, my lord, so there has to be, my lord, requirement of this, my lord, and kindly see paragraph 70.3 at page 39. So the point which I was
What do you want to say about this paragraph?
The point I was making, my lord, that it has to be authorized. The point I was making, my lord, that this the agreement, the 53, I was reading for the purpose of authorization, and these are the parameters which have to be followed. Paragraph 70, my lord. Next judgment, my lord, is NK at page paragraph NK and paragraph 8, my lord. Paragraph 8 of NK, my lord. Paragraph 8 at page 48.
Paragraph 8.
8 at page 48, last two lines of paragraph 8, my lord. A contract, whether by a formal deed or otherwise, by person not authorized by the President, cannot be binding in is absolutely void.
So see, a contract with a formal deed otherwise.
Otherwise by person not authorized by the President. So authorization by the President, my lord.
Analogy, the governor has not authorized. You mean to say that this is without any knowledge of the
knowledge
government.
Knowledge can be, my lord, there to us.
Can he be signatory at all? After he obtains the approvals from the competent authority.
After the person who is authorized to sign.
It's not a question of a person totally outside the system who's signing the deed. It's a question
in all
of a
government
person
matters, my lord,
who's been dealing with the petitioner,
yes,
who's within the system, who has entered into a
yes, my lord,
contract.
In all government matters, yes, my lord, in all government officers are within this system, my lord.
Yes.
All government, including Commissioner of Transport, is within the system. Applications are being forwarded under the statutory rules. Government grants the permission. Then thereafter he is authorized to enter into the agreement. So if he is not authorized, my lord, and no sheet of paper has been shown by the petitioner showing that this person has been authorized to enter into the agreement. I have shown 2017 agreement when the agreement itself clearly says that government has authorized to enter into the agreement. No cheat. So if person is not authorized, he may be part of the system, my lord. That is
he can be the authorized signatory.
He can be authorized signatory.
But in this case, he was not authorized.
He was not authorized, my lord.
Okay.
Because the law, statutory rules require under the rules of executive business, my lord, only after the permission has been granted. In this case also, my lord, facts are somewhat similar. Agreement has been entered, all correspondences have been entered by director, but only secretary was authorized to enter into the agreement. And the court said the facts I will show, my lord, paragraph 9.
Which one is that? The first.
Paragraph
NK.
Yeah, NK, my lord. Paragraph 9, my lord.
Yeah, okay. Read it.
We do not, now 8, my lord, the crucial question which arises for determination is whether there was a concluded contract. If there was one, whether mandatory requirement of 299 of the Constitution for entering into a valid and binding contract have been satisfied. It is now settled by this court that though the word expressed and executed in Article 299(1) might suggest that it should be a deed or formal written agreement, a binding contract by tender and acceptance can also come into existence if acceptance is by person duly authorized on this behalf by the President of India. A contract, whether by formal deed or otherwise by person not authorized by President, cannot be binding on, and is absolutely void. We do not for the present consider it necessary to go into question whether and what extent a requirement of 299 have been complied with in the case. What we have first to ascertain is to whether, apart from contention relating to 299, a concluded contract has come into existence as alleged by respondent. Before us, a detailed argument were addressed on behalf of appellant to show that notwithstanding letter of acceptance of 15 July, no concluded contract had come into existence, and though the later accepted certain terms, there were certain other essential terms of contracts which had to be agreed to and were subject matter of further negotiation between the parties. That it was intention of the parties that all those terms were to be embodied in formal contract to be executed, which contract alone was to be binding between the parties, and in any case, letter of acceptance and subsequent letter were not by the Director of Railway Stores but by the Secretary of Railway Board, who was not a person authorized to enter into agreement between the President of India, represented by Ministry of Railway and respondent. On the other hand, the stand taken by respondent was that all essential terms of the contract were agreed to, and the contract was concluded on 15 July 1968, though at the instance of Director, Railway Stores, further terms with respect to the execution of contract were the subject matter of negotiation between parties, and in any case, these did not pertain to essential terms and could not on that account detract from binding nature of the concluded contract. It was also contended that letter of acceptance by PC Oak, though signed on behalf of Secretary Railway Board, was in fact on behalf of the said board, which was authorized to enter into the such contract. It is in our view unnecessary to consider the several contention as to whether all essential terms of contract had been agreed to, or that contract was concluded by acceptance letter dated 15 July 1968, or whether parties intended to be a terms of the contract that a formal contract should be entered into between them and in order to bind the party. In this case, we are of the view that Secretary to Railway Board, on whose behalf the offer of respondent was accepted, was not the person authorized to enter into contract on behalf of President of India, as can be seen from the various documents already extracted. Tender notice inviting to be addressed by President through the Director of Railway Stores, Railway Board. Under the general conditions, seller was defined to mean President of India acting through Director Railway Stores, and in default clause it was provided that their buyer fails to execute the contract, seller will have the power to hand the Director Railway Stores, Railway Board to declare the contract end. In the letter written by Oak in May 25, 1960, as earlier noticed, it was pointed out that respondent that their offer was not addressed to the President of India as required under clause 1(3) of the instruction of tenders. Therefore, the respondent were required to confirm that offer can be deemed to have been addressed to President and is open for acceptance on behalf of President, and their replies should be addressed to the President of India through Director of Railway Stores, Railway Board. Even though draft contract dated in terms of which respondent were insisting on final contract to be sued to them by the appellant was to be executed by respondent as a buyer on the one part and President of India acting through Director Railway Stores, Ministry of Railway as the seller. There is a little doubt that only person authorized to enter into the contract on behalf of President is Director Railway Stores. It is true that notification of Ministry of Law issued exercise of power so and so that President directed the authorities named therein to execute in this behalf the contract and assurance of property is specified. But notwithstanding this, President is fully empowered to direct the execution of any specified contract or class of contract on ad hoc basis by authority other than specified in the notification. Court in Bikaji earlier held that authority to execute contract may be conferred on a person not by rules expressly framed by formal notification issued in this, but may also. In this behalf, letter of acceptance dated 15 July was on behalf of Secretary Railway Board, who is not authorized to enter into behalf of the President, my lord. So, Director Railway Stores was authorized, my lord. And here the contract was signed by Secretary who was not authorized. Here, Commissioner of Transport is not authorized, my lord. Therefore, merely because he has entered into the contract, my lord, in the name of the Honorable Governor, the contract is not binding because we are governed by a system of statutory rules where permission of the government.
Correct, but it detected after 1 year.
Now this even, my lord, if the contract initially is void without any authority.
Right, okay, yes.
If it is a contract is void, my lord, whether it is after 1 year or 6 months, no premium can be attached to the unauthorized contract, my lord. So my argument on this point, my lord, is, and recently also there is Supreme Court recent judgment, my lord, at page 52, my lord, recent 23 judgment also is there, my lord, on this issue. And the relevant paragraph is, my lord,
Glock
12. Paragraph 12, my lord. Yes, my lord. Glock Asia. Paragraph 12, my lord. Only one paragraph. And these all relevant paragraphs, my lord, I will not repeat. We will first deal with the submission of learned S.G. Bhati that contract in the present case stands on different footing as entered into the name of President of India, because this was pleaded, my lord. Article 299 of Constitution of India provides all Sorry, paragraph 12 at page 59, my lord.
Yes.
But we will first deal with the submission of learned S.G. Ms. Bhati that contract in the present case stands on a different footing. As entered into the name of President, 299 of the Constitution of India provide that all contract made in exercise of executive power of union shall be expressed to be made in the name of President. The phrase expressed to be made and the word executed are intended to mean that there must be a deed or contract in writing executed by a person duly authorized by President or Governor in that behalf. 13. The rationale of Article 299(1) as explained in Chaturbai Vittal Das Jasani versus Moreswar Parsuram is that this is a constitution bench judgment, my lord, is that there must be a definite procedure according to which contract must be made by the agents of government in order to bind the government. Otherwise, public funds may deplete by unauthorized or illegitimate contract. Because if I have a contract, my lord, and if I am running through the department and I am earning more revenue, my lord, and I can go for fresh tender after 6 years, my lord, and person who is not authorized, who enters into the contract, ultimately it is going to deplete the public revenue, my lord. It implies that contract not couched in the particular form stipulated cannot be enforced at the instance of any contracting party, my lord. It must be emphasized, article only lays down the formality that is necessary. It is important to note, does not lay down the substantial law relating to contractual liability, which is to be found in general terms. So it is for the reason the contract may be formally, because in that case, sovereign power, so that was not accepted, my lord. And Bhikaji, this constitution bench judgment is at page 66, my lord. Paragraph 17 and 18, my lord.
So you mean thrust is this one now, of the case?
Yes, my lord. If on this basis, my lord, on this basis, I saw that this agreement is not under the rules your lordship has seen.
Unsustainable, you mean?
Yeah, under the rules your lordship has seen that permission has to be by government. There is no permission by the government. It is not even pleaded case of the petitioner in the writ petition, my lord.
What do you want to show the judgment?
Yeah, this judgment, my lord, is constitution bench judgment at page 66, my lord, because this is the judgment which is being followed in all matters till today, my lord. At page 66, and relevant paragraph is, my lord, 17 and 18. (18) 17, my lord. It is clear that parliamentary intended to enact the provisions of contained in 175(3). States should not be saddled with liability for unauthorized contract, and with the object provided the contract must show on their face that they are made on behalf of the state and in the manner prescribed by the person authorized, my lord. Both requirements. The provision, it appears, is enacted in public interest to invest public servant with authority to bind the state by contractual obligation incurred for the purposes of the state, my lord. It is in the interest of public that the question whether binding contract, my lord. So my humble submission on the reading of all these case laws, Article 299, rules of executive business, and in the facts of the case, my lord, and statutory rules, my lord, the contract, though expressed in the name of governor, has been entered by the person who was not authorized to renew the contract. Manner of authorization is very clear in the statutory rules, my lord. Rule 6 says that will be done only after the permission of the government. And admittedly, my lord, there is no permission by the government. All those letters which your lordship, after your lordship's order have been forwarded, my lord, I can take your lordship through correspondence, but my learned friend has already shown those correspondences. The Commissioner of Transport has repeatedly written, my lord, to the government. Just show me those letters.
The one you produced a bunch of papers.
The bunch of papers, and they are part of the record, my lord. Part of the record.
Second petition.
I have filed those letters along with my affidavit, my lord. Yes, my lord. Kindly see those letters, my lord. At page 16.
Affidavit.
Page 17.
Affidavit. Those here.
My affidavit, my lord.
File in 299 or file in 8?
8 of 2024, my lord.
Yes. Yes.
Page 12, my lord. With reference to the Commissioner of Transport is this withdrawal letter is there. Now, your lordship, that I will deal separately, my lord. Your lordship will see 30th May.
Where reading?
Page 19, my lord. Yes, this page 19, my lord. 11th May 2020. In this connection, I have to honor to inform you that licensee so and so expired on 1st March 2021. Moved the code for renewal. In the meantime, department has requisitioned the weighbridge to temporarily ensure there is no disruption or loss of revenue till the decision taken on the petition of renewal. Honorable High Court, in the judgment dated, allowed the petitioner to move for renewal within a week, which is to be processed by the department within the month. Copy is allowed. Licensee has moved the department for order is not. Government is requested to kindly accord approval for renewal as per the direction. So he is seeking, my lord. He knows that he has no permission.
Yes.
Then second letter. All these letters, my lord, letters after letters. 22, my lord. 20th May. Last line. Government is requested to kindly accord approval of renewal.
This letter 11th May.
11th May, there are two letters.
11th May, one is a
three waiver bridges. First is page 19, my lord. Page 19 is the.
We are concerned with page 20.
Page 20, sorry, page 20, my lord. Page 20 and 22, your lordship will see again 22, there again 22. There are three letters, my lord.
Right, okay.
Yes, 24, my lords. And say they are all identically worded letter, my lord. And 20th June.
The commissioner was aware that that the proper procedure was to get.
Yes, my lord. That is the statutory rules, my lord. Leave no scope. And on 25. So. What I submit, my lord, is that why a proper procedure is required for government.
So what about other web bridges? Are you allowed to operate?
I have no instruction. I have no idea, my lord. I have not taken instruction on those matters.
Then the thing is that you say 6 years the cutoff.
So your lord,
similar fate,
yes, they have to.
Negative equality.
If they are continuing, they have to go. I have no difficulty. But before your lordship, the issue my friend has.
Of course.
Yes.
We'll confine there. Only.
Yes, ma'am.
Now, what are the documents to show?
Yes. So this what I have shown on my first premise, my lord, is that this agreement confers no right.
Okay. Let me. Okay.
So this agreement confers no right, my lord. And admittedly, it is a commercial agreement, my lord. Admittedly, it is a commercial agreement, my lord.
Yes.
Secondly, main orders of the government. 20th June, August order of the Transport Commissioner refusing to accept, those orders have not been challenged, my lord.
20th June letter.
20th June letter, my lord, even 1st August letter, my lord, by which...
Where's the 20th June letter? It's not here.
Your lordship
By
will
an
see...
affidavit, my lord. That was not addressed to me. By an affidavit, I have placed it on records.
Because
I filed an affidavit.
Subsequently.
Yes.
No, these letters are there. There is a reference, my lord. Before this writ petition was filed, petitioner was having a copy of this letter. It was part of the writ appeal also, filed by petitioner against the interim order, my lord. So to say that I was not aware of 20th June letter,
I'll make my submission.
I was not aware of the 20th, even your lordship will see 14th July letter, by which extension was granted. The letter gives reference to 20th June letter only of the government.
Yes.
So to say that I was not aware, my lord, in my humble submission will not be correct. I was aware, and if I was not aware, my lord, there is a, I can kindly see this letter of the August also, when at page 90. 90
of the petition.
Yes, my lord. With reference to the subject cited above, I am to return herewith the original copy of Challan, second and third installment of annual fee, as the government has conveyed its approval for extension agreement up to 30th September 23. This is also not because this is also not challenge, and the
No, but earlier petition they said that for asking for acceptance of challenge.
no,
Prayers there.
lordship, I will come to the earlier. Now earlier in petition, I will show what was the prayer there, my lord. What was the prayer? What my friend says that it has become infructuous. Earlier in petition, because by virtue of the subsequent order, if the Commissioner Transport is saying that I am withdrawing A or B letter, my lord, he can't withdraw the 20th June letter of the government.
Okay, yes.
And that letter could have been extended, and that letter said what? Up to 30th September only. So therefore, by relying on the letter of Commissioner Transport, my lord, by bona fide error or something, that letter, but it will not give you right in law. You have to show your right in law to run the weighbridge, which will come from a validly executed agreement in accordance with the statutory rules. Not on the basis of one letter here and there, my lord. My submission is this, my lord. And what on the consequential order, my lord, I have 2-3 judgments, my lord. Page page 82, my lord, is the judgment starts 2010 1 SEC 756, and relevant paragraph is page.
One second.
Sorry.
Edu Kanti.
Yes, my lord. Edu Kanti, Kistmata through verses 94.
Consequential.
Paragraph 22 at page 94, my lord.
Only problem with citing this paragraph, you don't know in what context sometimes the judgment
Because
is passed.
this
That's
was
why
the-
the court sometimes
but I
lawyers
have
just
to-
cite the paragraph, and when the court goes through the judgment, they find out, like it's
My lord,
converse.
because
It's
I have
happened
to,
many times.
I have to sometimes when positive of time, these are requires lengthy hearing where all entire judgment should have.
Yes, it requires him, because this is a very interesting point.
Yes.
Whatever it is, that means that the onus is on the state also. I mean, why has it indulged in such kind of roundabout action?
That should not have been done. My lord, I can't say, because the process is, because why we have got statutory rules, why have got we process? Because so nobody can hoodwink whether it's a government official or private person, my lord. So all the time our endeavor should be to show that the government is carried out in accordance with the rules. If somebody is, and that is how we can maintain probity, transparency and efficient working of the system. For these purposes only these rules have been evolved, my lord. But we are at nascent stage, and sometimes we see.
Yes.
94, my lord, paragraph 22.
Yes.
It is a settled legal proposition that challenge to consequential order without challenging the basic order, a statutory provision on the basis of which order has been passed cannot be entertained.
Yes.
Therefore, it is a legal obligation on the party to challenge the basic order, and only if same is found to be wrong, consequential order may be examined. Then there are 3-4 citations, my lord, I have referred by Justice Chauhan. Justice Chauhan used to refer all the judgments at one place.
10. Yes.
So I have, first, my lord, I have placed the judgments that the agreement was entered by a person who was not authorized. Second, I have mentioned, my lord, in consequential order. Third point, I have mentioned, my lord, that even under the renewals, the maximum he could have got up to December 23, my lord. Beyond that, he could not have. Then, my lord, all the other judgments, my lord, one judgment I will cite of the Guwahati High Court.
Only one paragraph is on this.
Yes, my lord, there are other paragraphs also, but I said that need not multiply all the, because the principle is well settled, my lord, that Supreme Court itself says well settled. And then, my lord, on the, kindly see the index, my lord, because nature of statutory contract merely entering into contract rules does. Index, my lord, of my judgment. Index of my judgment.
Okay. 2000.
Yes, my lord. So, lordship, all these provisions are well known to your lordship. I will not be, in order to cut short time, my lord. Your lordship may kindly have reference to all these laws, and taken that I have placed it, my lord. But I want to place one judgment at serial number 10, my lord, 159. Statutory contract, non-statutory contract, my lord. I can go this. These are not all statutory. The contracts entered by statutory authority will not make the contract statutory, my lord. But kindly see the judgment of at page serial number 10, my lord, and that judgment is Kemlan Suyam. Yes, my lord. 159, 181. Now kindly see paragraph 2. This is based on the same rule, my lord, which are there before your lordship. Paragraph 2, after 4 line, my lord.
To the page?
Page number will be, my lord, 166.
But just Ansari is known
159
for
and
verbosity.
Yes, Mr. Ansari.
Yes, Ansari wrote one judgment on MSc matter over 100 pages.
Even in IA matter, my lord, still that in IA matter we are saying, and CBI section 5 matter also. Those are pending, and those are pending still. They have not been able to overcome those judgments.
Apart from the stay orders.
Yes, and based on correct interpretation of, according to me, now matter. Now paragraph 2, my lord, at page 166. The government's after 4 line of paragraph 2, my lord. The government's policy decision not to grant extension or renewal of permission after expiry of the existing term has been taken in the larger interest of public, and the same does not call for any interference by this court in exercise of court extraordinary jurisdiction under article. This was the submission advanced by the state in this matter, my lord. Now, paragraph 3. With regard to petitioner's claim that some of the way bridges allowed to function even after expiry of their respective terms, respondent have contended that those way bridges are continuing on the strength of various order of the court. Respondent categorically stated that the affidavit position that government has not granted renewal in respect of any lease agreement in state has decided to set up joint integrated check facility in national highway so and so to facilitate so and so. So and so. This was the submission, my lord. And then, my lord, at paragraph 5, my lord, during the pendency of the writ petition, the petitioner obtained a copy of policy decision dated 2010, challenged the validity of said policy by filing another writ petition which has given rise to so and so. Paragraph 5 at page 167.
Yes.
The petitioner has, those are the submissions, my lord. The provisions are identical. Paragraph 13, your lordship will come at page.
What do you want to show by this judgment?
I want to show that the rules have been, and in the rules have been interpreted, and in the rule 3, 4, 5, same rules which are subject matter of same rules. Same rules which have been interpreted and said that it is the prerogative of the government to grant or not to grant permission. And no writ will lie, my lord.
Correct, but then in this case what has happened is that it's been given one hand, taken away again.
No, but that is the question, whether it was given or not, that has to be decided by your lordship. My submission is that even assuming I accept the argument for this, for my lord, that it was given, my lord. Still, whether government is denuded of its power not to renew the agreement, my lord, at what
As acting under the rule.
and under the and what we have to say is, my lord, petitioner will be at best. Tomorrow I take a decision, my lord, that government decides that all agreements renewed will not be further renewed, and we will be running our own departmental way bridge next to the petitioner at best will be entitled to damages only, my lord. No specific performance can be informed. This is like a commercial term. It's like a specific performance of commercial term.
Yes.
Paragraph 14, my lord. Having heard the learned count 13, my lord, and on the careful reading of the material, we find that no dispute the petitioner way bridge is situated so and so, nor is there a dispute that despite the fact that provisions of renewal of permission as regard to way bridge of 2009 rules, and there is an agreement with the petitioner on the paragraph 13, my lord, at page 169.
Yes.
Because this was the...
This is a case of straight denial for renewal.
renewal. So now the question is that we have not, the government has not renewed the agreement.
In this case, yes.
Yes, government has not renewed the agreement.
That is why you came for renewal.
And
so there was a interpretation of the rules itself.
And we have not renewed the agreement, my lord, whether by deemed, and if there is no renewal, he can't run the way bridge. It's a deemed refusal.
See, this case is very, this present case is very tricky. In a sense that
the law, in my humble submission, my lord, is
law is very clear, but the facts are very
facts are also, to my respectful submission, my lord, is clear that this is an agreement entered by Transport Commissioner without any authority. There is no authority, and statutory rules. Your lordship will see paragraph 18.
Reflected in affidavit.
Yes, I have said so.
With regard to
Yes, my lord, I have said so, and I have said there is no paragraph 18, my lord.
Okay, read it.
From the executive instruction, kindly, even the rules 2009 do not permit installation operation without permission having granted in terms of provision contained in 2009 rules.
Judgments also, the other hearings also.
Tomorrow.
Tomorrow, my lord.
Tomorrow, I don't know what case.
And second half also we can have it.
Maybe.
Or your lordship may have it on Friday. I am here whole week.
See, the problem is that this court is only sitting till Thursday first half. Again, it's very difficult.
Let it be, my lord. We'll give it a try tomorrow. Even if it is the second half, my lord, we'll ready. I'll only make a brief reply. I won't make it long, my lord.
No, there is some very interesting points.
Very interesting.
Very interesting in the sense that you see, he has changed the complexion of the. He changed the complexion of the entire thrust of the. Very well done. He's changed the whole complexion.
We'll try, my lord. Persuade your lordship. Both of us will try to persuade that. The lawyers know the case. It is said only judge has to know the case. Lawyers know their respective cases.
Yes. Who are the other hearings?
Item 13. 13, your lordship.
Item number 13, I had a small proposal, my lord.
Because MS P. Chetri took holiday last time, the whole thing got derailed.
My lord, what has transpired now, my lord? The one post is vacant, my lord, because of Akar Assembly's retirement. So, my lord, if they are okay with that, we'll advertise that post, my lord. If they're age barred, we'll relax that.
Because once you know that, anyway, that's up to them. Consider it's not for the court to pass any orders.
That was I was proposing, my lord. One post has become vacant now.
What post become vacant?
Magistrate, my lord.
But judge retired, how the magistrate post become vacant?
Because
being direct recruitment for judge.
no, my lord, judge is already Madam Lathma is judge now.
You can produce notifications also. Last time also we're not
I have the
aware.
notifications,
We're not aware as to when, who took over, who took charge when, and who was promoted. We don't have that also.
I have the notifications, my lord. I have brought it, my lord.
You got the information now?
No, Your Lordship.
Why?
Your Lordship, it's not uploaded in the official website, Your
You
Lordship.
go and collect it from them.
I have the
Go to
copies.
the council, correct? Then why? If you want to advance your case, you collect all the information required.
If they are okay with that, we will advertise the
No,
post.
question of being okay with that or okay with this. We have to laws. We have to see the case. Let them go back with that information if they'll apply whatever. I don't know. The court
Otherwise, Lordship, I filed my written arguments. The matter may be decided on the basis.
No. We'll need submissions. Because some questions you have to answer. Based on written arguments only based on you only giving the law as according to your understanding will help your case. The court has some questions. That is why. Do not that's why I said to show because the fact every case is peculiar.
Yes,
You
Your
understand?
Lordship,
Like
it's
general
true,
law,
yes.
something even the most overwhelming case material you have also, it's like that. Like the case you're hearing just now.
Yes,
If you hear it prima facie, it's very open and shut. Extension has been given
Yes, Your
and they
Lordship.
stopped. Why have they stopped? But then you heard Advocate General arguing why it was stopped. So there's a lot of it behind.
Your Lordship.
You argue it, why not? Last time we would conclude it the next day or something, but then yes, the other matter go to Item
Item 13.
Item 13, not 13 go on.
Supplementary.
Yeah, ma'am. Advocate General.
Oh, okay. Supplementary.
This for further hearing tomorrow. What about other matters before this? Your first matter is yours?
13.
Yes,
13.
The problem because this court won't be available again. I won't be here till 18th from day after tomorrow.
No, the next week after that is holiday.
So there.
No, you kindly take instructions also. And you get all the materials.
But they want, because they've come by a writ petition, they want a right to participate. So we are advertising, they can, if they are overage, we'll consider that.
Not just right to participate, Your Lordship.
This is
we
not
are
a PIL.
challenging.
This is a writ petition.
It's not a question of them being deprived and then, that you'll be appointed. You see, that's the thing.
Yes, Your Lordship.
It's not a
When I
PIL that
was
they
a
want
lawyer
a
also,
reason.
long time ago, as a young lawyer also. So same kind of thing happened. And but then I couldn't, my petitioner was not qualified that day. So it was a very, there was Chief Justice that time, Justice Bijesh Mishra, very learned judge. So he said for me, you heard of the term, what sauce for the goose is sauce for the gander. You look up that term. So the same thing, you're not going to get anything. No, so that's the thing. So anyway, that is another thing altogether. You kindly prepare his.
One aspect of the matter is it's too late in the day to anticipate whether that appointment was irregular or.
There are circumstances, but the thing is that doesn't mean that they came to court on time. They came still after the.
They should have come immediately after the publication of that. They did not do so.
We came, Your Lordship. We came. It was not so much delayed.
She will argue that. That is why they will raise this question. You'll have to meet. You have to meet arguments on the facts of your case. That's why.
Yes, Your Lordship.
See, to have just written arguments is only when actually oral arguments are concluded. It's just actually this court doesn't like written arguments. It's only to give the bullet points, argument, and citations. So anyway, what trick was he?
We come in first week then.
Then you prepare. We have first week of May. Okay.
Nice.
Yes.
First week of April.
Oh, first week of April. Sorry. Yes.
16.
In March. Yes.
Obliged.
Obliged, Your Lordship.
16.
Carolina.
16.
Hey,
May it please Your Lordship.
you ready with the hearing?
No.
Oh, you're waiting for so long, yes?
I pray for some accommodation, Your Lordship, as the conducting counsel. He had left the premises due to some personal difficulties.
What is your name?
W. Rumbai.
How many years you practice?
6 months, Your Lordship.
Very good. Yes, on the request of Dr. Rambai, this is a matter after 1 week.
Yes, Your Lordship. Highly obliged.
After 2 weeks, man. 1 week. After 2 weeks.
2 weeks?
It's okay, Your Lordship.
It's okay, okay. Very interesting case, this one. This, yes. Very interesting in the sense that, you know, it's like, is there any estoppel against law? Very interesting.